Hey, what's up, guys? I'm just here to do a quick video recapping a serious legal problem with Kim Potter's guilty verdict in Minnesota that was rendered just a couple hours ago at the time of recording, right? So, Kim Potter, for just a brief refresher, was the Minnesota police officer, actually in Brooklyn Center, Minnesota, who famously yelled, "Taser, taser, taser," before firing her firearm and killing a young man by the name of Daunte Wright. This case happened in the wake, I guess, of Derek Chauvin and George Floyd, and during all of the protests. And this killing actually sparked a lot of protests on its own, and therefore brought a lot of turmoil into the city, the metro area of Minneapolis and St. Paul, based on what had happened. This was seen as a crime of racial violence by many, many people out there. Now, very importantly, nobody in this trial, there are no facts brought to this trial that suggest that any racial animus, implicit, explicit bias, any of that occurred. That was not a fact argued at trial. So if your entire premise is she's guilty because white police officer shot brown individual, that is actually not a narrative that was in consideration in this case. Maybe jurors thought about it, but it was not argued, it was not presented. And believe me, if the prosecutors thought that that would give them an advantage in this case, they would have definitely utilized it. But that being said, this is a crime with the charges of first and second degree manslaughter. Now, the first degree manslaughter charge in this case is really important as well because it is predicated on this idea of an underlying misdemeanor or gross misdemeanor or felony action misdemeanor or gross misdemeanor, sorry, not felony, that would be felony murder, that led to the death of an individual. And in this case, the underlying misdemeanor that the state chose, that the state presented, and that the state argued was reckless use of a firearm. That puts this in a unique situation because that means that the elements of first degree murder or first degree manslaughter and second degree manslaughter are both recklessness. At the end of the day, that's what it boils down to. So, first degree manslaughter with the underlying charge of reckless handling of the firearm actually obviously needs recklessness. You have to recklessly handle a firearm. And the second degree charge just is more broad, saying that culpable negligence is required to be shown in this case. Well, what is culpable negligence? That's where a big part of this is going to hinge. Culpable negligence is gross negligence with an element of recklessness. I've covered every minute of this trial on my channel. You can watch live streams that are multiple hours long that go through the entire case from jury selection all the way through to verdict if you really want to do that. But the end of the day, you've got this element of recklessness that needs to be proven by the state in both of these charges. So, what is recklessness? We have to go down this definition chain. Culpable negligence is gross negligence plus recklessness, and recklessness itself is its own thing. So, before I do that, let's talk briefly about why culpable negligence has to involve recklessness. Okay, this is a concept of criminal law called mens rea. It's the appropriate state of mind for criminal action to occur. You have to do something. You have to intend a criminal act, or I should more appropriately say an act that can be found to be criminal for you to actually be guilty of a crime. If you don't intend to do the act, which may then be criminal, then you cannot be guilty of the thing. All right. It's a weird sort of process, but the reason for this is we don't actually punish people for innocent mistakes, even if the results of the innocent mistake is catastrophic. For example, resulting in the death of someone. That's what a wrongful death civil suit is for. You didn't have the requisite intent to do the act which caused the damage, but you negligently did the act which caused the damage, and therefore we punish you civilly. But we don't take away your liberty forever because you did this thing, even though the consequences are grave. Criminal law is not a consequence based, it is not a consequence determinative sort of approach to legal issues. The questions are, what actually happened, what was the intent to have that happen, and then what were the results. It's a holistic approach to it. And sure, the consequences are an element of what crime may be charged, but the underlying act is what is important. For example, you can have several different things with the exact same underlying act, just with different results. The criminal element of it is proven by the act and the intent to commit the act, not by the result. I hope that's as clear as mud, but it should serve our purposes for this video. Okay. So then we need to have some level of intentionality to charge a crime. So that's where recklessness comes in beyond just negligence. And with that, I want to talk about a Minnesota case, State versus Frost. This is from 1983. And this case has an excellent definition of what culpable negligence is and consequently what recklessness means. Since we can use the recklessness for both of these charges, that should help make the determination of whether or not this was appropriate. I will contend from the outset that these charges are not appropriate because I don't believe that the state actually proved recklessness in the way that the law defines recklessness. I think what the state did was proved negligence and then told the jury that recklessness was negligence. This is a criticism that we had, we being the panel of lawyers and I that watched this trial and specifically watched the closing arguments. Now, we had with the closing arguments from the state. They frankly misstate the law on recklessness and they apply a negligence standard. So this video serves to show people why we believe that using Minnesota case law. And I don't think there's a better way to show it than to show what the law actually says. All right. So this is again from State versus Frost, and I'll just go ahead and read through some of it. The state's interpretation of the elements of the offense, and this is second-degree manslaughter under a culpable negligence theory, is based on State versus Bielke. Bielke interpreted the statute, which provided that homicide is manslaughter in the second degree when committed without a design to effect death by an act, procurement, or culpable negligence of any person, which according to the provisions of this chapter does not constitute the crime of murder in the first or second degree, nor manslaughter in the first degree. All right. So this is manslaughter in the second degree by culpable negligence. It is more than ordinary negligence. It is more than gross negligence. It is gross negligence coupled with the element of recklessness. It is intentional conduct by which the actor may not intend to be harmful, but which an ordinary and reasonably prudent man would recognize as involving a strong probability of injury to others. But remember, it is intentional conduct. You must intend to create this risk. The difference between the terms recklessly and negligently, as thus defined, is one of kind rather than degree. Each actor creates a risk of harm. The reckless actor is aware of the risk and disregards it. The negligent actor is not aware of the risk, but should have been aware of it. Minnesota Statute 609.205 defines second-degree manslaughter in terms of culpable negligence, whereby the actor consciously takes the chance of causing another's death or serious injury. This definition corresponds with recklessness as defined by Wharton. In Bielke, we called this kind of recklessness intentional conduct which the actor may not intend to be harmful, but which an ordinary and reasonably prudent man would recognize as involving a strong probability of injury to others. But remember, the risk of the injury must be conscious. As Zupitz indicates, second-degree manslaughter under this section involves an element of awareness of the risk by the defendant. Stated differently, the statute requires proof of an objective element and a subjective element, the objective element being gross negligence, and the subjective element being recklessness in the form of an actual, conscious disregard of the risk created by the conduct. This interpretation is based on the wording of the statute itself and further is in accord with the view espoused by the drafters of the model penal code that liability for manslaughter should not be premised on inadvertence to risk, that is, disregarding of a risk of which one should be aware, but on a conscious disregarding of a substantial and unjustifiable risk of which one is actually aware. That is the issue that we have in this case. Kim Potter, by all of the evidence in this case, is not aware that she is holding a gun rather than a taser. That is a substantially different risk profile. She cannot possibly be aware of the risk a gun creates if she's not aware that she's holding the gun in the first place. And I know it may be hard to believe that she is not aware that she's holding a gun, but these types of errors do in fact occur, and they do occur very often. They had an entire expert in this case, an unrebutted expert, by the way, who came out and testified about how these types of action errors occur, how they occur in everyday life, and how sometimes they can have very, very grave consequences. Action error is not a novel concept in psychology, and it is not a novel concept in criminal law either. In fact, it has been used as the basis for acquittals in numerous cases throughout the years. Because we don't punish people for genuine mistakes. We punish people for intentional acts that may not be intended to cause the level of harm that they cause, but were disregarded to the amount of risk that happened there. The end of the day is this. If you point a taser at someone and pull the trigger, you have a certain level of risk that you are aware of, and then you disregard that level of risk by pulling the trigger for whatever reason, right? You're disregarding that risk because it's justified, for example, or because you're really mad at the person. There are different reasons to disregard the risk. Some of them rise to criminal liability, others do not. But the point is, when you draw a taser, there's a different risk profile than when you draw a gun. One is called lethal force or deadly force. One is less lethal force, and it's less lethal for a reason. The risk of death from a taser is significantly, significantly lower. And it is not something that is consciously disregarded in the same way that the risk of drawing a gun is. And that is why the taser is on a different place on the use of force continuum for a peace officer than a gun, and why a gun is justified in deadly force situations where a taser is justified in something less than deadly force situations. So, if you believe that Kim Potter made a mistake, even if you think that mistake is ridiculous, even if you think the results of that mistake are catastrophic and unfathomably painful for the family, which they are, even if you believe that, then you cannot convict her of manslaughter in the first or the second degree. Under the law of Minnesota, it is not a tenable position to convict on these two charges. Now, if you believe that she manufactured a story, that she knew that she had the gun in her hand, she lied and said taser, or whatever thing there was, then you can go ahead and get to this idea of culpable negligence. If she knew she had the gun in her hand, if she knew she drew that gun, then she does create the risk that a gun provides. And then she disregards that risk by pointing the gun and by pulling the trigger. That is the critical difference here. The problem with that belief is that it's not supported by the evidence in this case, and it's not supported even by the arguments of the prosecution. What the prosecution ultimately did in this case was they conflated the ideas of negligence and recklessness to create an entirely new theory of law on how recklessness applies in Minnesota. It's an extremely dangerous theory of law, because it puts criminal liability on all sorts of people who are merely negligent. And that is not how criminal law is supposed to work, because criminal law involves your essential liberty rather than merely making someone whole for damage that you have done. With that, I hope this helps explain the verdict and why I think it is legally incorrect. You're free to disagree with me. If you do disagree with me, I would encourage you to do it based on law rather than based on emotional sort of charges about what you think may have happened, how you felt about her incompetence. No one here is arguing that Kim Potter acted competently in that situation, but incompetence is not always criminal. And in this case, I don't think it is. With that, guys, thanks for watching. Hope you have a nice time, and I'll catch you soon. Peace. Peace.